Hello, welcome. My name is Henry Lynn Pear. I'm the senior counsel here at Manifest Law. Gonna, gonna give it a minute or two for more people to join in, and then we can get started with the Q&A. Where's anybody tuning in from today? So today we have a sort of a general Q&A. That means there's some questions that people have been submitting ahead of time before the event started, and I'm going to be going through those questions beforehand, and then see how much time we have. Once I get through the submissions, then we can open it up live for some questions in the chat and see how many questions you have. I'll try to get through as many as I can. All right, let's get started here. Number one, what are the best pathways to move from temporary visas to a green card? There's no one best pathway for everybody, right? Every person's life journey is a little bit different, and different factors to consider. The best pathway, I think most people mean fastest if they ask for the best one, right? Or the fastest or the easiest. So if you are somebody who's coming to the United States with years or even decades of work experience and a lot of accomplishments, then the easiest way or fastest way to go to for a green card is to pursue something like an EB1A, which is the extraordinary ability, but it requires you to show that you are among the top experts or the top achievers in your respective fields. Um, for somebody who is on a student visa, or maybe on the OPT or still on a J1, then most of the time people in that situation don't yet qualify for the EB1. There are exceptions, of course. There are some people who come to the United States to study after they've already worked for a long period of time, and then they do their degree, their OPT, things like that. Or, for example, people come to do a PhD and then stay on a J1, maybe as a research fellow or something like that. And these are good candidates often for EB1A. Or EB2 NIW, which is another category where you can self-petition, meaning that you can apply for the green card without requiring an employer to sponsor you. Statistically speaking, the most common way somebody gets a green card is through family sponsorship. But of course, if you are here on a student visa, the odds are that you don't have immediate family in the United States who could sponsor you. So that might not work, or not might be a likely option for you. And then, of course, there's the employment-based categories with the employer sponsorship. So that means if you have an employer that is willing to help you and wants to keep you around, and for that, I suppose the strategy is, once you get a job on OPT, be incredible at your job, make yourself irreplaceable for the employer, because they are often reluctant to spend money on sponsorship and deal with it, especially smaller businesses. They haven't even dealt with any immigration stuff. They don't know how the system works, and they're not familiar with it. Of course, there are the big companies like big tech and big banks and so on that are already very familiar with the immigration system, and they have their very specific policies on sponsorship, but smaller businesses often don't. And if you're working for a smaller enterprise, then you have to basically really prove yourself before they would consider sponsoring you and trying to even figure it out. But if you make yourself irreplaceable, then even somebody who's previously been against it might become open to it because of how much they want to keep you around. Let's see what else. From O1, uh, the very likely transition is to an EB1, right? Because if you are on an O1, you've already demonstrated some level of extraordinary ability. The bar is a little bit higher for the EB1A, but it's usually the logical next step. So if you are on an O1, you're already on the right track, and you just keep doing more amazing things, and soon you will be ready for the EB1A as well. Trickier on the temporary protected status because you don't know necessarily when that's going to end. But depending on how long you've been here on TPS, some people have found a spouse, for example, in the United States. Then the marriage-based adjustment of status is the most likely pathway for them. All right. Let's see. What are the current approval trends, risks, and policy changes for high-skilled visas and green card categories? Uh, approval trends, risks, and policy changes. Overall, I would say the risk is just that um, going for visa stamping is becoming a little bit more unpredictable because there's reports from different sources of people getting denied for different reasons and often not even receiving a good explanation of what was the reason for the denial. For O1s, for example, I have heard more and more O1s getting denied for immigrant intent, which never used to happen before, but now on the embassy and consular side, it has been happening. But I don't know the exact percentage of that. But in my opinion, if somebody is in the US and for some reason they require consular processing for an O, then I would really talk to an attorney before leaving to review their file thoroughly and see if there's any red flags on whether they should be going. That really applies to other visa types as well, but especially with an O because it's not a dual intent. So H1B is dual intent, which means that if you're going for stamping with an H1B, then, for example, having an approved I-140 is not an issue. Same thing for uh, uh, like pending I-140 or I-130 if there's a family case pending, things like that. That doesn't matter for H1B, but it could have an impact on O1 or F1 or J1, things like that. With, let's see, CPT history. Somebody's asking if H1B stamping risk for with CPT history. CPT is risky. I have to be honest, I'm no expert on the CPT because I don't do many cases. Usually that's something that people handle on their own and just discuss it with the university. And as an attorney, I only see some CPT stuff after the fact. But just this week, I saw somebody came for a consultation because they had done multiple CPTs with different universities, going through multiple different programs. And then when they were changing status to um, B2, I think, then they got a request for evidence from USCIS asking for proof that the CPT programs were all related and the jobs that they worked during CPT were all related to their field of study. So, for example, if you are going for an H-1B stamping and you have spent considerable amount of time in the United States on CPT, then I would say um, document everything well, right? You should go in prepared to explain exactly what you did at your job and bring things like transcripts from the university and the detailed job description from the job so that you can exactly mark, okay, what did you do at the work job, and how is that related to the different things that you were studying at the university, because you have to be able to explain how the job was related to your major. And because if it wasn't related to your major, then they can say that that was a violation of your status. But if it is related to your major, then that's a valid use of the CPT work authorization during studies. Um, Expected updates to EB1A criteria in 2026. Honestly, that's complete speculation at this point because there's no updates out yet, right? So if the government hasn't published anything yet, I don't have a spy on the inside to tell me what's going to come out in the next month or two. But what I would expect to happen is for them to put maybe more information about final merits requirements into the regulations. Other than that, uh, they can't really do that much with the criteria because the criteria for EB1 are written into the Immigration and Nationality Act, which is a statute that only Congress can change. So all they can do is change the interpretation of the existing criteria that's already there. They can't just say we're not going to accept scholarly articles anymore, for example, but they can write a regulation that's more detailed than the statute that says here's what counts as a scholarly article, and then maybe exclude some of the things that have been previously accepted. Like maybe they previously accepted somebody's Forbes Business Council a thought leadership article as a scholarly article because it's read by business executives. But they could write a regulation that says that's not a thing anymore. But we don't know if that's going to happen or not, like I said. But yeah, one of the big things I would expect from any upcoming regs is going to be related to the gold card and the platinum card, right? So one of the things that I think they're trying to do is put the gold and platinum cards into the EB1 and EB2 categories. It doesn't mean that the existing EB1 and EB2 are going to be terminated, but it just means that they're fighting for the visa numbers because there's a limited number of green cards available each year, and so if the president creates this gold card, it has to take numbers from somewhere. It can't just make up a new category out of thin air. So that's one of the main things that I'm concerned about is if this actually goes through, because I do think there's lawsuits going to be on that topic. But if it actually goes through, then it just means that the wait lists on EB1 and EB2 are going to be increasing over time, even more than now. Okay. We have a few more here from the previously submitted that I'm going to get through before I jump onto the ones in the chat. Thanks for being patient with me. What counts as strong evidence for EB1A or EB2 NIW, like citations, publications, original contributions, critical role, etc.? Well, for EB2 NIW, you don't need to be the most amazing person in your field. It's really about specifically what are you doing now. And there, if you are a researcher at a university, then yes, of course, publications matter and citations matter. Or, for example, if you have been, creating some kind of new technology or something innovative, then whether that's actually being used by somebody else, that's going to be a big factor. But for NIW, um, the biggest thing why cases are getting denied is national importance, and national importance has to do with the proposed endeavor. The EB2 NIW is basically you telling the USCIS, give me a green card so that I can do X, and this X is something that's very valuable for the United States. So it's not just about what you're doing now, but you have to provide a statement or a detailed plan about what you plan to do in the future, and that's the X. Your future plan is the X, and then you have to explain why is this X something that's really good for the United States. So for example, if somebody's working on cancer research and machine learning, then their X is I'm going to create new machine learning algorithms that are going to help diagnose cancer faster. And this is valuable for the United States because the faster we can detect cancer, the more people we're going to save. And so it's a public health benefit for the United States to let me stay here and keep doing this. Or for example, maybe you are working in some kind of a industry role in the energy sector, and designing new power grids or data centers or something like that. Then there's going to be different arguments of why is the US benefiting from what you're doing. The challenge there is that USCIS wants to see evidence of how your work, what you're planning to do, is going to have an impact more than just on your direct employer, which makes many jobs weak for the NIW purpose, because the if the benefit is just you're doing a good job for an employer and they win from that, but it doesn't really impact society or the economy on a broader scale, then it's hard to win a case. And that's what I see with a lot of industry cases. The strongest cases for NIW right now are still researchers, and then uh, people who do any kind of work for the government. So that means either you work in a government agency, in a state government or local government, and you're applying, or maybe you're working in the private sector, but you do a lot of government contracts. So, for example, if you're working in a startup and you're doing some really innovative stuff, and you have multiple contracts with federal agencies that you're working with, then you have a good chance for an NIW, because the fact that the government's already contracted you is evidence of itself that you're doing something that's of national importance. So it's not a linear comparison with the EB2 NIW and EB1A. EB2 NIW does not require you to be the best at what you do, but it does need to have this national importance component. So it's like it's got to have a broader impact. If you're just a really good IT guy in one company, then even though IT used to be a hot topic in NIWs, those cases are not succeeding as they used to. But for EB1A, there doesn't necessarily have to be such a national importance component to it. It's more just about how good are you, and if you are really in the top 5-10% of people in your field, then you may qualify for the EB1A. But now the biggest thing for EB1A is what they call final merits, which is basically the USCIS officer looking at the big picture. So if you've looked at EB1A at all, you know that there's these categories of evidence they call the criteria, and everybody's focused on the criteria. How many criteria are going to get? But what you really care about is the final merits, the big picture. You need at least 3 criteria to get through round 1 of the analysis, but then you go to final merits, and there the officer is basically making a subjective determination of, do they believe that you are one of the top people in your field. And what they want to see in final merits is that people outside of your immediate employment know who you are, right? They want to see reputation. They want to see what's called sustained acclaim. And what that basically means is, who knows you exist, right? So people who are weak candidates for EB1A generally, even if they have a lot of experience, are, for example, IT consultants who've been working in a consulting company on the H1B for 20 years, but they've not done anything outside of their IT consulting job 9 to 5, right? Because they make for weaker cases, because it's even hard to explain how their role has been critical for the company, because they're doing jobs for other companies, and then also because they never get credit publicly for the amazing work that they do, right? So you might be doing, you might work for Accenture and do some amazing big project for a Fortune 500 company, and then nobody tells anybody that you did it, because if it even gets in the news, it's all about the Fortune 500 company doing a big new project, but they don't even say who helped them, right? So those cases are weaker. But people who are good candidates for EB1A are people who have publicly available evidence, because it's not just about recommendation letters, what people can say about you, but it's about documentation that's independent, right? That wasn't just created for the purpose of the petition. USCIS loves to see business records like reports, PowerPoints, emails, anything from the companies where you've worked at that existed before you decided to go for an EB1A, that you can show that, look, here's documents that show that I was leading this project, and how it ended up as a great result. How to how many publications or citations are enough? That really depends on your total profile. If you are a researcher, then you should have a lot of them in order to prove that you are one of the top researchers. If you are an industry person, but you just want to have some research papers on the side as sort of a sprinkles on top to to improve your case a little bit, then 2 to 5 added on is pretty good. But in terms of citations, again, if you're an industry person, you were not expected to have citations comparable to a full-time professor. But if you are trying to show that you are one of the top researchers in your field, then you need to look at how many citations do researchers in my field generally have, and then how do I compare next to them. And you need to be prepared to give this frame of reference to USCIS for a comparison, because the officer that's reading your case doesn't know the subject matter, right? They don't know if in speech language pathology, whether the normal is 100 citations or 1,000 citations, or in AI, whether it's supposed to be 100 or 1,000, right? So if anything you want them to know about your field, you need to include in the case, and then that's going to be valuable evidence for you. For example, I did a case for a engineer working in the renewable energy and microgrids field, and then in their own field they had about 400 citations, and we could show with some filtered search from Google Scholar and things like that, we could show that they were one of the top like 5 or 10 people in their field with this amount of citations, right? So it's not always easy though, for each field to get that data. But if you can't get it, then you can create the reference point. What is the high and low in your industry, and then present that to the officer, and then say, here's where I stand on this spectrum or this scale. How to differentiate original contributions from normal work. So the, the the emphasis here is that the regulation asks for original contributions of major significance, right? So that means original contribution means it has to be something that never existed before. So for example, if you get approved for a patent, that means that's a legal determination from the Patent and Trademark Office that you created something novel that never existed before. But if you don't have a patent, but you just did something at work, that's like, oh, I built this framework or this platform or software that's first of its kind, then you need testimony from people to say that, yeah, something like this never existed before, or maybe there's media coverage about it, right? Because if it's something really innovative and new, then maybe there's a news article that says, hey, look, this company launched this new thing that's never existed before. That's proof of originality. Now, point two, you also need proof of major significance, and that's all about impact, right? So for example, you can have a patent, original contribution, but if nobody's using the patent, there's no major significance, right? And a lot of people have patents that are filed in companies, and then they're never used. So an ideal situation would be you have a patent, and then you also have proof from the company that they are using your patent in one of their key products, and then that's where the major significance comes. If you're like, hey, I created this patented technology that is now part of the flagship software as a service platform that the company offers, and we have Fortune 500 companies as our clients, and everybody loves it, then there's like a huge increase in revenue for the platform. That would be the major significance, right? The part that somebody's actually commercializing it, and others are using it. Or if you create something, then major significance would be that a lot of others are using it. So excuse me. So, for example, if you're a researcher, then a high citation count can be evidence of original contribution of major significance if you show that it's got a really high count on citations, and that means that it's generated broad discourse and impact through the research field, right? So, if you discover a new isotope as a physicist, and then there's, I don't know, hundreds or even thousands of citations, and now every new paper that comes out that is looking into this, like testing it, trying to see if they can replicate, or trying to do tests or experiments with this new isotope, then basically, that shows that, like, from your work, an entire, you know branch of new studies are coming out, and that's a huge impact for somebody from that. Or if you're more in industry, maybe on the open source side, then major significance could be something like, I wrote some code that went into the Linux kernel, and then now there's 300 million devices around the world that are using the software code that I created for the Linux, that is, I don't know, improving cybersecurity across the world or something like that. If you can show that scale, then that's going to help you prove the major impact. Um, what counts as critical role when working at the same company for 10 to 15 years? Um, that's so critical role means that you have to be doing something that's of high importance for the purpose of the company. So, for example, if you are working on the software at a software company, and it's the key architecture or fundamental architecture for how their software offerings work, or how their technology works, so that it can offer those services to all of its customers, then that would be something that you consider as a critical role. So the time you've spent in the company is not necessarily itself proof of critical role, but if you've been around for long enough, then there's a higher chance that you've probably done things that are considered critical for the company, because that's, probably the reason why they kept you that long, is because you're doing a good job. Um, Mainly, you need recommendation letters, but like I mentioned before, USCIS really wants to see something else besides recommendation letters. So if you can show emails, PowerPoints from some project summaries, or maybe some project plans where it shows what's your role in a specific project and things like that, then that can help uh, prove that the role you have is critical. Whether AI founders, researchers, and operators can combine technical and business contributions. Absolutely, they can, but you have to then explain very well the connection between those things, right? So, for example, if you're the CEO of an AI company, and then your background previously is building AI models, and or being a full stack developer, or data scientist or something like that, then that connection makes sense. But you still have to, don't take it for granted. You still have to explain it. It makes sense to me, but the reader at USCIS might be somebody who studied history and is now reading immigration. So you have to make that connection explicitly in your petition, and explain to them why that's relevant, and maybe bring examples, right? And say, hey, look, here's Elon Musk is a engineer, and he's running these tech companies, and here is Sam Altman, and he's running OpenAI, and so on and so on. That you have to show that if you're running a tech company, you have to understand the technology, right? So it's not like you just need somebody with an MBA to come make the decisions. It's a different ball game, and if you can make that connection, explain the need, for why do you need to have the technical expertise, and how that makes you, you know, qualified for also now the CEO role, then I think you can use different aspects of your career. But it does, the more those go further apart, the more challenging it becomes. So if you've had like a real pivot in your career where you did development, and then at some point you transition into sales, and then uh, uh, in a different industry or something, that's going to be tricky. But if it's a same or similar industry, then at least you can argue that, hey, my background as a developer is making me better at managing the sales for these technology companies, right? So again, it's got to make sense, but it is possible, absolutely. How to strengthen a borderline profile before filing? It really depends on how much time you have or how patient you can be, because what I'm seeing lately is that USCIS is pushing back on cases where a lot of the evidence was generated in the last few months before filing. So if you're hoping that, oh, I'm just going to work on this for 2 months and then file, your profile is going to look a lot weaker than if you have more accomplishments, more publications, more judging opportunities, things spread out over a longer period of time. So if you just do one conference appearance to give a quick speech and get a photo, and then you file for EB1, that looks a lot weaker than if you can show that, hey, in the last 3 years, I've attended 8 conferences, and every time they asked me to go and present something, right? I did a poster presentation or maybe even a keynote speech or something like that. So the more spread out the evidence is, the more organic it looks. Second, the battle is in the final merits, which means that anything you can do now that is public facing is going to help you boost your case. So whether that means going on a podcast, even if it's a smaller podcast, it might not be big enough to count as major media for the media publications criteria, but in final merits, it still helps. So, for example, if you're from India and you know somebody who's running a podcast in India for people who want to get into the tech industry in the United States, then maybe you can go in as a guest on there talking about how did you get to the US and made it to where you are today, right? And then you can use that in the final merits as, look, people are looking up to me as an authority, as somebody who's already made it, right? So that means that's good evidence for final merits. As in the tech world, for example, there's also all these platforms for mentorship programs and meetups and networking opportunities. So anywhere you can go where you basically help recent graduates and set yourself as like, I'm the one that's giving the advice, not getting the advice, then it shows you as a leader in your field. Also, volunteering in nonprofits or helping advise, early stage startups or something like that, could lead to really good recommendation letters in the long term. It's not a quick thing though, because you might be advising, being on the board of a nonprofit, or maybe being an advisor for some early stage startups. They might not get anywhere until like a year or two later, right? Which means that until the startup then actually succeeds in some sense, until then they don't have a good testimonial for you, right? Because the power of the testimonial is going to be, he helped us with improving our tech, and now our tech is so good that we got funding and we're valued at, I don't know, 100 billion, right? That's an amazing testimonial. But having a testimonial from somebody whose startup hasn't really taken off yet, it has a lot less of a wow factor for USCIS. So the more time you have and the more organically you can do it, the better. But usually when people like start looking at this, then they're already like, okay, now I want to do it fast, 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 fast. And then that's really the balancing act. There is like, if you have more time, then there's a lot of things you can do to build your profile. But if you're asking for, okay, how do I get ready for an approval in the next 3 months, for example, then it's hard, because even if you look for judging opportunities, then you might get a book manuscript for review or something, and it's going to take you 2 months to get that done. or someone might say, hey, we have a competition that you can go be a judge for, it's in February. And then you're like, well, I don't want to wait until February to get it done. But that's where you're at, right? Like there are so many things that are outside of your control, and the only way to really build the profile is if you put a lot of work into it and you give it time. Can you change jobs while I-140, I-485, or O1, H-1B petitions are pending? What risks or employer obligations exist? Well, that's a lot of different things combined in one, so it's hard to say what's the right answer here. If you have an I-140 pending, if it's your I-140, if it's a self-petition, then yes, you can change jobs. If it's an employer petition, you can change jobs, but then the employer that you're working for right now might withdraw that petition. If you have an I-485 pending, an adjustment of status, then it depends on what's the basis of the 485. If you're adjusting based on a self-petition, again, you can change jobs. If you're adjusting based on a marriage case or other family case, excuse me, then you can change jobs. But if you're adjusting based on a perm, then you can only change jobs if you're 180 days into the 485, and then you have another employer who's willing to take over the case. So that means, like, let's say company A does a perm for you, does an I-140 for you, and then finally the priority date is current and you file an adjustment of status. If the adjustment of status has been pending for 180 days or more, then company B is allowed to port that uh, approved perm and I-140 and just file one form with USCIS, and then you can get a green card still and start working for company B instead. But if it hasn't been 180 days, or you don't have a company B that's ready to port the case and take it over, then if you leave the company now, then USCIS can deny your 485. And even if they approve it by accident because they don't know that you left your job, then you can get in trouble later because there is an issue with the fact that a perm is a promise of a future job. And when you're filing the adjustment of status, you're saying that that job is waiting for me and I intend to take that job. And then if you leave that job, the company, before the 485 is approved, then you're showing that you're not actually going to take the job that the perm was made for. And then they can later come back and take away the green card because they say you never took the job that you did the perm for. So the green card was issued in error. What job changes are allowed? The job change must be to a job that is substantially similar. And the definition for that is that about 50% of the job duties and responsibilities have to be matching. So that means that if it's for a software developer role in a different company, um, then it should be fine. But if you're looking at completely different industry, or going from engineering to management or something like that, then it might not work. So if you are looking at porting, then you should definitely talk to an attorney and do a detailed review of the perm that was approved and what's the job description for the perm, and then what is the new job that's being offered, to make sure that it's got a good chance of working out, that it's not going to get denied. When it comes to H-1B or O-1, then if those are pending, then those are temporary visas and they're tied to specific jobs or things that you want to do. So there might be exceptions for an O-1. I can think of some, but generally, if you have an H-1B transfer pending, then if you're transferring from company A to company B and you are inside the US, then the moment company B files the H-1B transfer, you can already leave company A and start working at company B. That's the portability rules for H-1B. However, um, if you have a case pending for company B and then you want to leave that one and go to a third one or something, then that gets really complicated, and you have to definitely file a new case for sure. Uh, but then if there's like a chain of multiple pending cases, that gets too risky. So I wouldn't recommend messing around with that. Like, I would wait at least for the next first case to be approved before you make another sudden change. What happens to okay? mm, You can maintain multiple petitions simultaneously. Yes, but not exactly the same petitions. So you can't have like three different EB1A filings pending at the same time. Um, Technically, you could have more than one EB2 NIW pending at the same time if they have very different proposed endeavors. Meaning that if the substance of the case is very different, then there could be multiple EB2 NIWs pending, and you can have an EB2 and an EB1A, for example, pending at the same time to see which one is more likely. But honestly, in my experience, um, the case comes out much better if I'm focusing on just one of those at a time. So trying to kind of combine things when clients say, "Okay, let's work on both and then file both at the same time." It's a disaster because they are different cases. Okay, so the letters, the strategy, it's all different, and it's very confusing, at least for me, to try to prepare both of those at the same time and maintain the same level of quality for both. So it's kind of like having a multi-purpose tool that is just bad at both things or multiple things, right? Like it's like if you have a specific tool for a specific job, then that specific tool is usually going to be a lot better than the one size fits all thing that is supposed to do everything, but then it does everything kind of not so great, right? So um, um, if you are going to file multiple, I would say pick one to go first and then work on the next one after. Or just prepare to have a lot of time, because you should, if you're trying to work on them in parallel, don't take any shortcuts or anything, because it's really hard to do it well. Let's see. What triggers H-1B fees? H-1B transfers, amendments, changes of status inside the United States don't trigger the H-1B fee, the 100K fee that's everybody's talking about right now. So if you're leaving the US after getting, let's say, F1 to H-1B, or H-1B from company A to company B, and then you try leave the US and travel, you shouldn't have any trouble coming back. Nobody's going to ask you for the 100K fee. At least that's the reporting I've gotten so far. I haven't seen anybody be stopped at the border or asked for that payment. Where the 100K fee applies is if somebody is physically outside of the United States when their employer is filing for their first H-1B, right? So it's written and designed in a way to make it more expensive for new people to come to the US on H-1Bs. But anybody who's already here, or in a different status, or who has already had an H-1B in the past, is basically safe from that fee, as far as I know for the time being. Like, I haven't heard anything otherwise. Can someone keep or renew F1, H1, J1, and so on while applying for an IW or EB1A? Yes, absolutely, but uh, need to look at the dual intent issues and prepare for them. So, for example, if you are an F1 and you apply for an NIW, then you can absolutely keep your F1 going by getting your DSO to update CVIS and keep issuing you new I-20s, do OPT event, and so on. That's not a problem. The problem comes when you leave the United States and you need a new visa stamp, because when you go into the consulate, they're going to evaluate you for immigrant intent. So, for example, I had a case that I helped somebody with an RFE response. They had already filed the NIW uh, uh, while a PhD student, and then they got an RFE and they came to me. When I looked at the RFE and prepared the response, then we responded, got an approval. So great story there. But right when we got the approval, they informed me that their F1 visa is actually expiring now, and they have a family emergency back home, and they really wanted to go be there for their family. And I told them, listen, if you go, you might not come back, and you might not be able to finish your PhD because you're in the middle of your PhD right now. And you can stay here and maintain F1, no problem. But the moment you go to an embassy in Nigeria and apply for an F1, they're going to look at, oh, there's an I-140 that's approved. You intend to stay in the United States, and they might just deny the visa. And then the PhD is one where you need to be there in person, so you wouldn't be able to finish that remotely. So you are risking, not being able to come back and finish the PhD if you leave now. So if you are planning on applying for an NIW, and you have a J1 or an F1 and you anticipate needing to travel, then I would say first do the traveling, do the stamping, get a visa for as long as you can, and then after you come back, then do the NIW petition to give yourself more time, because the wait list for on the NIW for green cards is going to be a few years. So ideally, you'd have like a 3 or 5 year visa in your passport, and then you apply for NIW. And that means that while the NIW, if it gets approved, hopefully you are on the wait list for green card, and then you have the visa in your passport, then you should be able to travel in and out, because on the border the CBP doesn't look for immigrant intent on like F1 or J1 visas when you have the stamp in your passport, but it's at the consulate where you have the highest risk. No, EB1A NIW does not jeopardize your OPT or or STEM OPT. So I haven't heard of anybody getting a denial on getting their OPT EAD or getting their STEM OPT extension just because they've applied for I-140, EB1A or NIW. Best options for IT professionals or families abroad who don't qualify for H-1B or L-1. Well, I would look at alternative work visas like O1, TN, E2, H1B1, J1 research. O1 is very good and flexible. It just has that high level that you have to show accomplishments. So O1 is great for entrepreneurs. So if you are looking at starting your own business or bringing your company from abroad here, then O1 works. If you're already running some kind of a company abroad and it's fairly big and successful, then of course an L1 is also a good option, because if you set up a US office or a US subsidiary, then you can use the L1 to transfer over. It's an intra-company transferee visa, so it's meant for multinational companies to move management and essential employees from one country to another, right? So that can be useful. TN is always good for Canadians if it matches the occupation list, right? TN has a specific list of occupations in the USMCA treaty, and that means that it's not for every job. But for example, for management consultant, there is a TN category, or for registered nurse, there is a TN category. For software roles, I think there was like a computer systems analyst or something on the TN category. So that might work. And then there's an engineering role. If you have a software engineering degree, then that works. But they're fairly strict on what the degree needs to be in. So you have to check with an attorney on whether your job and your education background and the treaty all come together and match. If yes, then you can get a TN. And of course, for clarification, TN is only for Mexicans and Canadians. It's not for people from other countries. E2 is great for small businesses and entrepreneurs, but it is only for people who have a passport from a country that has a treaty with the United States. I've done a lot of E2s for small businesses so I'm from Estonia, and I have a lot of people contacting me from Estonia saying, hey, how can I come to the United States? And most of the time, I review their profile and I say, well, unless you have a sponsor who can do something for you, then your most realistic bet is to do it yourself, which means investing money in the US and then applying for an E2. It requires spending some money, usually at least 30,000 or more. A lot of attorneys say like E2s require 100,000 or more, but vast majority of E2s that I've done have been way less than 100K, because the clients I've had, they just don't even have that kind of money. The lowest I've done is about 20,000 something, and it was them investing in 50%, and then another 50% was put in by an American. So combined, they had about 50K, but the applicant from Europe specifically only put in about 20,000, 20 or 25,000. And after that, the full business owned by one person, I think it was about 33,000 or something like that, that I got an E2 approval for. So it doesn't always have to be like an insane amount of money, but it really depends on what is the type of business that you are building. So you cannot get an E2 by just registering a company and saying, I have a consulting business, right? You need to have some money spent in the United States for equipment, premises, technology, registrations, website, licensing, maybe some staff or contractors if you need them, different things like that. And the company has to really have a potential for creating jobs and growing substantially over the years. The stereotypical example of an E2 is like somebody coming and buying a gas station or a store to manage, right? And those are usually about 100,000, or could be less, but you know, um, it depends on the location and what state and all that kind of stuff. H1B1 is a great one. It's kind of like the E3 in Australia. So H1B1 is like the H1B, but it's for people from Singapore and Chile. And then E3 is like the H1B, but it's for people from Australia. Basically, it's the same process almost, a little bit easier even than the regular H1B, but it's based on treaties between the US and those countries. And that means that there's no lottery because they haven't used up all the numbers that they have allocated for those visa categories. Um, for E2 or TN, like there's no limits, so there's no lottery. There's H1B is the one where's the lottery system. J1 for research. Yeah, J1 for research roles is also a good one that I've seen more and more startups starting to use. So certain IT, but mainly I would say like not just like IT in general, but like certain AI machine learning roles can get a J1 as a researcher, because they are kind of heavy R&D roles, right? Like if your job is to come uh, be basically the person that is developing new LLM models for an AI startup, then that's basically a researcher position. It just happens to be a researcher that's doing something with software rather than a researcher that's doing something in like a chemistry lab. But I have seen that there's more and more startups that are using the J1 researcher visa instead of the H1B. Whether employment-based immigrant petitions can be filed from abroad. Yes, absolutely. If you are filing an I-140, it doesn't really matter physically where you are. You can file it. There are some considerations for different case types of what's better. So, for example, for an EB2 NIW, I would say nowadays, if you file it from abroad, um, you're going to be at a disadvantage compared to somebody who's already working in the United States, because somebody who's already working in the United States, the fact that they have somebody in the US paying for them to work here is already in itself evidence that they're doing something valuable. So if you are outside of the US and you're filing for an EB2 NIW and you have zero connections to prove anybody's interested in your work in the US, then it's going to be very, very hard to win an EB2 NIW. But if you are already collaborating with researchers in the US and you're just working from a different university somewhere else, or if you have company connections or something like that, then it could be doable, right? So for example, I did an NIW for a business analyst who is working out of Europe, and uh, they've done some work for a US AI startup in like the fintech space, right? So we got a good recommendation letter from the CEO in the US saying that thanks to this person, we have AI that's now like 98% accurate or something like that at predicting stock prices or something. And then, that was really powerful evidence showing that, like, even though they are in Europe, they have already done something that benefits the United States. But if you don't know anybody here and you're just saying, give me a green card so I can go in the US and look for a job, that's not going to be a winning case. Okay, let me see if I can uh, take any of these here from the chat as well. Okay, how to transition from H1B as a software engineer to O1A? Well, I mean, it depends on what's your profile looking like. I mean, if you've already done some really amazing things as an engineer, then the only thing you need is a change of status petition where you just submit all the evidence to USCIS and show how amazing you are as a software engineer. But if you don't have these accomplishments, if you've really been kind of grinding it at the office and you don't have any exposure outside of your current employer, then the first step would be to schedule a consultation with Manifest and review your profile and give you some pointers on what to do with your profile to improve things and get you on the right path, right? Because it's going to be a long journey to get the kinds of evidence that they want from an O1 to get you out there speaking and mentoring and just getting as much attention as possible, basically, because that's what we want to show, um, that people know who you are, not just your employer, but other people in the industry know who you are. And then after O1, EB1 is next. It's just that in theory they are the same kind of thing. One is temporary, one is green card. In practice, EB1 is like here, right? So it's like a lot harder to get, than O1 has a lower standard a little bit. So if you get the O1, it's basically like a good validation that you're on the right track for EB1, but you're not maybe there yet. And then you just continue doing the profile building and continue doing really good work, and then you'll get there on the EB1 as well. If you um, want to go out and become a manager and come back on an L, that's a great thing to do if your company is willing to support you with that. And larger companies are starting to do more and more of that. I see it because the L1A is the transfer visa to bring you back later. It's not subjective, right? It's not based on how amazing you are as a manager. It's just that whether your role is a managerial role, and then they can bring you in. Same thing goes for the EB1C, which is the L1 mirror green card version. So if your company is willing to support you for an EB1C, then all you have to show is that you qualify for that L1 rules of having a managerial role and having worked abroad for at least a year full time. And then that's it. You don't have to be the greatest manager in the company or anything like that. So bigger companies are using this pathway a lot. And I think it's going to only increase over time with the H1B becoming so much more expensive and more difficult. Uh, here on an E2, manager of my business in Argentina and the one here. Uh, I would say the companies have to be large, right? Like not like Apple large, right? But I mean, if you only have like a couple of people, you're not going to get an EB1C, right? USCIS really wants to see a three-tiered structure or a three-leveled structure. So there should be you as the CEO, let's say, and then a middle manager or supervisor, and then people who are doing the work. But if you are so small that you are still doing a lot of the work and you still only have some contractors or assistant or something, that's not an EB1C. And if you are the immediate supervisor to the people, like let's say you run a trucking company, and or let's say you run a store and you're the manager and you just supervise the clerks who are working and the cashiers and stuff, um, like that's not an EB1C role, that's an that's a supervisor role, but you need to be one level up from that. So I don't have a specific number, but generally if it's 5 to 10 people total or something, then that's probably very low chances of happening. So if you are growing, then I would say contact us, and let's take a look at the structure of the companies and how big are they on both sides and stuff. But I think it sounds like you have a way to go still before you could do that. Does one need an underlying visa like H1B or O while applying for EB1A? Um, well, yeah, because the EB1A petition itself doesn't give you any immigration status. So if you if you submit the I-140, then that doesn't give you status or right to work or anything. You need something else. And if your priority date is current, so for example, if you're not from India but you're from Germany and you file an I-140, you are allowed to file the I-485 adjustment of status concurrently at the same time. Or if you're from India and you have an old I-140 with the current priority date, you can submit your EB1A and the adjustment at the same time. But it is better to have that H1B or O1 underlying while you're waiting for the adjustment of status as a backup, because if you file and you don't have any underlying status, then if for some reason the adjustment of status gets denied, you're out of status, and then you have to leave the country quickly to not get in trouble. How does filing for asylum uh, impact other cases like U4U extension or EB2 NIW? Could you file also simultaneously? The problem with U4U and asylum applications is that they are not considered as legal status. They are sort of a gray area in the law where you are not out of status, so you're not here illegally, but you also are not in valid immigration status. It's sort of a middle ground there. You can apply for multiple of those things. So you can have an asylum pending and a U4U at the same time. That's fine. But the problem will come later if you're trying to when you're trying to actually get the green card. So if you apply for asylum and you don't have any other underlying valid status like H1B or O or F1 or anything like that, then even if you get your EB2 NIW approval, then you have to wait for the green card wait list. And then once you're through the wait list, you want to apply for adjustment of status. But you're not eligible to adjust status if you are not in valid status at the time that you apply for adjustment of status. So that means that if only thing you have for several years is asylum pending or U4U, then you're not eligible for adjustment anymore. And the only way you can get a green card is by leaving, applying at an embassy, and then coming back. And for some people, that might not be an option or might be too dangerous. So that's why um, it's really tricky. So if you have asylum pending or U4U, then just talk to an attorney before you do make some big decisions, because it's pretty complicated with some of these humanitarian options. How can one transition to H-1B to green card if one aspires to be a music producer? I've never done a music producer case on an H-1B, and I don't even know if that's possible. An H-1B is for a specialty occupation, which is a legal term meaning that it's got to be a job that requires a bachelor's degree or higher to perform in that job. And there's a bunch of producers who don't have any formal education, as far as I know. So it might be difficult to actually qualify for an H-1B with such a role. Um, it might be that you need an O, because an O is great for artists, but it is a high standard, the O1B, that you need to be really really good at what you do. I did a O1 for somebody who was a producer for music videos, and that's a pretty cool case. But they already had produced videos for some pretty well-known award-winning artists. So it was a very strong go. All right, we're already over time, so I'm gonna stop there. Thank you so much for everybody who's tuning in and listening. I'm sorry I didn't get to. There's so many questions on the chat. I think next time we can just go straight to the chat questions instead of the pre-submitted ones, and maybe we'll get through more. If you check the link in the chat, then please, I think it was manifestlaw.com/webinars. Oh, here we go. It's on the screen too. Then you get a discount if you hire Manifest for any case, and you may qualify for a free consultation. Just contact our team, and we'll collect some information from you about what's your background and what kind of a visa are you looking for, and you may qualify for a free consultation or a discounted consultation, and hopefully we can help you get some advice and figure out what's the best pathway for you. Thank you very much for everybody tuning in. I'm Henry, and hopefully I will see some of you soon.